Hello everyone, welcome to my new video which is on the Civil Procedure Code 1908. So I'm specifically talking about the section 27 which is about like summons to defendants. So let me read the definition of the Bail Act. So then I'll explain the section. So summons to defendants where a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and may be served in the manner prescribed on such date not beyond 30 days from the date of the institution of the suit. Okay, so let us go through the what exactly the section 27 is talking about. Okay, when a suit is properly filed in the court of law, the court may issue summons, okay, to the defendant, which is nothing but the issuing a notice to the defendant saying that a case has been filed against him and requiring him to appear in the court, and he should be answering all the claims which are filed in the plaint. Okay, so the summons should be served within 30 days from the date of the suit is instituted. Okay, and like when we wanted to explain it in a very easy way, like after a suit is filed, like the court sends a official notice to the defendant. This summons tell the defendant that a case has been filed against him, because it is necessary to inform the defendant that there is a suit which has been filed against him and he should be prepared to come on the such date to the court, saying like, so that like he will be prepared and come and respond in the court of law. Okay, and the law ensures that this process happens promptly. Okay, and within 30 days of filing the suit. The key objectives of filing like of section 27 is like informing the defendant about the case. Okay, because if we don't inform, the court has a responsibility to inform the defendant, and if it doesn't inform the defendant, so he'll not be aware of the suit which is filed against him, so he doesn't get a fair chance of representing himself, uh, and there would be unnecessary delay, like the defendant is not appearing in the court even though the suit has been instituted. So the other party should know that there has been a suit which has been instituted, and what are the claims which the defendant needs to answer in the court. So he should be aware of that and well prepared before coming to the court and answering them. So that is a reason why, see, there should be a notice which should be given to the defendant. Okay, and I would like to say that like if you are like once a lawsuit is properly filed, okay, so the court can issue a summons to the defendant. Okay, so the summons is an official notice. Okay, so it which informs the defendant that there is a case filed against him, so and it asking him to appear on the date, okay, which is mentioned, clearly mentioned in that summons. Okay, and should respond to that claims. Okay, whatever these the claims are there in the plaint, so those claims needs to be answered by the defendant. Okay, the summons should be served in the manner as prescribed by the law. Okay, require the defendant to appear in the court on the date, it's not more than 30 days from the date of the suit was filed. Okay, so the purpose of this rule is like there should be a timely notice which is to be sent to the defendant. Okay, and it prevents the unnecessary delays in starting the case. Okay, and it also promotes the speedy justice, because once the plaint is filed in the court, there should be a proper information which we sent to the defendant, and defendant, if he responds in a timely manner, the trial will start in a timely manner, and it will give the proper time for both the parties to give their side of the story, and the evidence needs to be presented. Then the court can come to the conclusion and give a judgment based on the representation of the case by both the parties. Okay, so now I'm just talking about the order 5, which is like a issue and service of summons. Okay, today in this video I'm going to discuss about only about the issue of summons. Okay, let us see the first point, which is on summons. Okay, the summons is as itself is very clear that like while issuing the summons to the defendant, it's a responsibility of the court and also the plaintiff to like to inform the defendant that there is a suit which has been filed and there are claims like 1, 2, 3, 4, 5. There might be like n number of claims which the plaintiff might be asking the defendant to present his version, and the court will also ask. So that like the court will look into that claims and the justification of the statement given, written statement given by the defendant. So all this will be observed before finalizing and giving the judgment. So and he shall be given upon the 30 days from, okay, from the date of service of summons. So if the defendant has taken the summons, has seen the plain which is attached to the summons, so there should be a copy which needs to be given to the defendant along with the summons. So the defendant comes to the court on the date which the court asks him to come and represent in that case. So if the defendant is accepting all the claims which are there in the plaint, so it's well and good for the plaintiff, so that the decision is very clear that he has accepted and the court can pass the judgment. If suppose the defendant comes to the court and doesn't file a written statement within the period of 30 days, then the defendant will be given a time like so that he can come with prepared and give the written statement. So approach the advocate and the drafting can be done. Then he can come the at the later date when the case has like the case will start upon like hearing the matter. So that next day the defendant can come next day or any other day which the court feels appropriate the defendant to come and file a written statement on that day. If he's coming and giving his written statement, it's well and good. So they would be given a like 90 days of time, so he can come and give us the written statement. If suppose if he's not still filing a written statement even after 90 days, then there should be a reasons which needs to be recorded. So even after 30 days the reason needs to be recorded. Okay, so but uh, after 90 days, so what happens is if the defendant still doesn't give his written statement, so the court will ask the reasons for not filing the written statement on time, and it also there should be some payment of such cost which needs to be paid by the defendant for doing like for delaying the filing, for delay of filing the written statement. So there should be like the court will give some more time, like suppose the written statement needs to be filed within the 120 days. Suppose the even after giving the appropriate time, the defendant doesn't file the written statement after 120 days. So the court shall refuse, okay, the defendant after filing after for filing the written statement, okay, because it's been 120 days and more, and if still the defendant is not filing the written statement, it shows this there is a gross injustice done to the plaintiff. That is the reason why the court shall not allow the defendant to file a written statement after 120 days of time, and the defendant shall forfeit the right, okay, to file the written statement. So he has no longer has the right to file the written statement, okay, after 120 days, okay. And the defendant to whom the summons has been issued, so he can appear in person or he can appear by a pleader and duly instructed and able to answer all the material questions related to the suit, okay. And a pleader and there he like the pleader can accompany by some person who can like able to answer all the such questions which are mentioned in the claims of the plaint, okay. So those person can come and appear and represent the case, okay. And every summons which is issued to the defendant, so it should be signed with a judge or like an officer needs to be appointed by the court, like so to serve the summons, and it shall be sealed with the seal of the court, okay. So an officer is appointed and that should be sealed by him and sent to the defendant, okay. So it is a kind of notice. So coming to the next point, which is like a copy of plaint annexed to summons. So as I mentioned earlier, like while sending a copy of summons to the defendant, there should be a copy of plaint which needs to be sent along with the summons so that the defendant will exactly know what, like why the summons has been issued on his name. So he'll be knowing the case. So he'll be going through that the plaint, and he can approach some advocate, then he can get this advice, and also it will help him to file a written statement, because without knowing the reasons why the plaint has been filed, he cannot come down after 30 days saying that, like I don't know the reason, but so that will like unnecessary like cause delay in the case. Okay, so that is about the copy of plaint annexed to summons. So next is like court may order defendant or plaintiff to appear in person. So the court will ask the defendant to appear in person. Okay, so if sees there is a reason that behind that his appearance is mandatory, so the court should order the 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 defendant to be coming in person and giving the written statement, okay, to be filed in the court. Okay, and coming to the next point, so no party to be ordered to appear in person unless resident within certain limits. Okay, the court will ask the defendant to come. See, there should be some reason. That is the reason why the court is asking the defendant to come in person. Okay, so if the person is within the local limits of original jurisdiction, then the court will ask him to come down. Okay, or like any, like without such limits, but it is the distance is less than 50 or less than 200 miles, the distance of the courthouse, then the court will ask the defendant to come in person and give us side of the story. Okay, so coming to the uh, like the order 5 and the rule 5, summons to be either to settle issues or for final disposal. Okay, so this in this case, like what happens is the court shall determine, okay, the court shall determine whether it's issuing the summons for the defendant to settle the issues only, or like they wanted to dispose the suit, the final disposal of the suit. So the court shall decide, okay, for what is the reason behind, like why it's asking the defendant to come personally. Okay, and then the summons should contain a direction accordingly. Okay, and it should be, if it is a matter heard by the small causes court, then the summons shall be for the final disposal of the suit. Okay, and so if it is like the small causes court, then it will not take a lot of time to decide the matter. So it will be asking the defendant to come down to listen to his side of the story and give the final order, saying why who like if the plaintiff is right, then the defendant will be ordered to pay certain amount of money, or like he'll be asked to do certain action which needs to be performed by him. So yeah, then it will decide the case then and there. Okay, so order 5 rule 6, fixing day for appearance of defendant. So the court specifically decides on which day the defendant should be presented in the court. Okay, and first place I have already told you that if the defendant resides well within the jurisdiction, so which is less than 50 miles, or like less than 200 miles in between, so then the court will ask certain person, like defendant, to come down to present his case. So then that exact date will be given in the summons, so that the on that particular day the defendant should come. Okay, and coming to order 5, rule 7, summons to order defendant to produce documents relied on by him. Okay, so here, like, see, summons will be issued. Okay, so if there are some documents which is in the possession of the defendant, then the court will ask the defendant to produce those documents, because which will support in his case. Okay, so it will be helping him, helping the defendant to give his side of the story along with the documents, so it can support him in the case. Okay, so that will help him actually. Okay, and coming to the next point, which is like order 5 rule 8, on issue of summons for final disposal, defendant to be directed to produce his witness. So court will also ask the defendant to get the witnesses which they feel that they are be used or utilized for the final disposal of the suit. Okay, so it shall also direct the defendant to produce on the day fixed for his appearance. So all the witnesses upon which whose evidence the defendant believes that they can support his case, and by giving the evidence in front of the court he can win the case. Okay, so during those situations, so court will ask the defendant to get the witnesses, his side of his witnesses, so so that his case can be presented strongly in the court. Okay, this is all about the issue of summons. So, and in the next video I'll be talking about the service of summons. Okay, thank you.